Welcome to my channel Law with Alashpa. Today's topic is common law. It's a very common question. What is common law? History of common law, significance of common law. So let's start with the history of common law. So basically in Anglo-Saxon times, there were local courts which decided disputes. After the Norman conquest in 1066, a more organized system of courts emerged. So he made different courts. How? Like the first Norman king, William the Conqueror, set the Curia Regis, the king's court. He appointed judges. Then the judges were sent to different towns to decide cases and disputes and also to disperse justice in the king's name. During the reign of Henry II, these tours became more regular. Country was divided into circuits or areas for judges to visit. Initially, the judges would use local customs or Anglo-Saxon laws to decide cases. Over a period of time, judges on their return to Westminster in London would discuss with each other the laws and customs they had used. In this way, the law became more uniform. And from this, the concept of common law developed. The phrase common law developed. There are also certain advantages of common law. The advantages of common law are like certainty in law. Law became more certain. It also became more flexible. According to the situations, judges can make a decision. So, in this way, the law became more uniform, common, and it is from here the phrase common law seems to have been developed. Common law is the basis of English law today. It is unwritten law that developed from customs and judicial decisions. An example is murder. Murder is a common law crime, while theft is a statutory crime. As murder has never been defined in any of Parliament's Act, but theft is defined by the Theft Act 1968. Common law is still used to distinguish laws that have been developed by judicial decisions from laws that have been created by statute. Here I'll end today's topic. Don't forget to like, share and subscribe my channel.